Hello, testing, testing. Can anybody hear me? Great. Our presentation will be starting in about 5 minutes. So please get your lunch and start making your way to your tables, and we'll be getting started shortly. Thank you.
Hello, hello, good afternoon, everyone. May I please have your attention? Hello, hello, everyone. May I please have your attention? Hello, everyone. Good afternoon, everyone. My name is Jen Wadeka, and I am your Property Management, Leasing and Property Management Committee Chair. Our co-chair is Mr. Brent Hull, and he's back there helping out with the food. I want to say thank you to everyone that's here. I know it's Monday, first week of the month, as you property managers know. It's busy for us, but I just want to let you guys know I am thankful and grateful that you guys are here. May I please have Mr. John Hogan to come in and do the Pledge of Allegiance for us?
Greetings, greetings, everybody, please rise. We'll start off with the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all. Honor the Texas flag. I pledge allegiance to thee, Texas, one state, under God, one and indivisible.
Thank you, Mr. John. Okay, a little bit about our committee, about your committee. Your committee is here to assist and provide GEPAR members who are dealing with leasing and property management, education, and experience resources, to be able to provide learning and development of their skills in order to comply with landlord and tenant issues, to comply with and provide guidance of local, state, and federal laws pertaining to leasing and property management. May all current committee members please stand and be recognized. Thank you for your commitment. If anybody would like to be part of the Property Management Committee, you can go ahead and register via your member portal. That way you're able to sign the confidentiality, all the papers that are required to be part of the committee. Our next meeting is going to be this Thursday, 3 p.m. here at GEPAR. Also, okay, I think that was it for right now. Let me have Mr. Brent Hull. He's going to be introducing our sponsors that have provided the lunch that you guys are eating today.
Morning, everybody. I'm Brent Hall. I'm the co-chair for the Property Management Committee. And I would like to introduce or have Chris Jody from Goosehead Insurance come up, as well as Gabby Quezada and Yasmin Ochoa from AAA Inspections. They were the ones that provided lunch today.
Good morning, everybody. Thank you for having us here and being able to sponsor this lunch for you. I just wanted to introduce our company to you. We're AAA Home Inspections. We are more than just a home inspection company. We are here for the community. Anything that you all need for, this past season with the winds and, an unbiased roof inspection. For your properties, if you find any mold, we do mold consultations as well. We do have a pest control department that can assist you with any pest control issues as well. And I left some flyers on top of your tables for Reliance Repairs. If you ever need any home repairs for any of your rentals, your property managements, we're here for you. So let us know. Thank you.
Hello, good afternoon, everybody. I hope you are enjoying the food. Awesome. My name is Christopher Jody. I'm with Goosehead Insurance, independent agency here locally in El Paso. Been in the business I've been in insurance for longer than I wanted to be. No, I'm just kidding. About 15, 20 years almost. You know, I'm licensed here in Texas and New Mexico. I basically do it all, personal lines, commercial lines. So if anybody, yourselves or your clients need any help, please let me know. I work with about 40 or so insurance carriers. So we can handle it all on the commercial side. I do have another end of the business, you know, where we're much more competitive than most. So if you all need anything, please don't hesitate to reach out. Did everybody get my business card? There are people who don't have it. Awesome. All right. Well, thank you all so much. And if you need anything, let us know. Appreciate it.
Thank you, Chris and Gabby. Please reach out to them for all of your needs and for property management. They're here to support us, so we need to go back and support them. Mr. John Hogan, I'm sorry you're eating. Also, we do have a big crowd. Once again, thank you. Thank you for coming out. It's always great to see everybody that is interested and always learning.
All right, folks. I have the honor and pleasure of introducing to you our guest speaker for today, our locally homegrown Justice of the Peace, Josh Herrera. Josh Herrera is Justice of the Peace of Precinct 3. That's downtown and central. And he has a lot of good information for you. He'll be doing a presentation. Towards the end, he'll be available for questions and answers. So here we go.
Good afternoon. I'm going to do my best to remember to keep this to my mouth, but if not, I'll just raise my voice so everybody can hear me, and I'll try to get to both sides of the room. First and foremost, thank you so much, Mr. Hogan, for bringing me back. I love representing to this group, or presenting to this group. My mother, Mary Herrera, she's in the back. She's been a realtor for some time. So as far as an introduction, that's where I came from, and this is where I am. Okay. I do practice law. I have practiced law. I started in 2009. So I know some of our JPs aren't attorneys. And I happen to practice law. Before I was a JP, I just started my second term. All the JPs are on the same cycle. We started our term in January 1st of 2023. This is my second term. The constables are on a separate cycle. They'll start up again in 2 years is when they have their cycle. Before I was a JP, I was a criminal law magistrate, so I've got some judicial experience. And when I started my own practice, I did everything that walked in through the door, and then I started with the DA's office. So kind of my niche has always been a criminal law on the private side. But as a JP, JP is an interesting court. If you've ever practiced in the court, if you ever had the privilege of practicing in the court, it is the people's court. It's where you can just bring in all your information, and we'll work through the weeds there. You guys only do evictions. If you ever been there on a private side, you know, people will often tell me, hey, you know, who would you refer me to for a car accident in a JP court? And I say this as the way I would tell my family. You can do it yourself. Okay? If you can get your evidence, you can do it yourself. We see enough cases that, you know, as long as we're able to digest the information that you present to us, everybody's going to get a fair shake. So if you think you can present that stuff yourself, bring it yourself. What type of stuff? Evidence, evidence, evidence. Okay? Just feel comfortable practicing in the JP court. I hope if you take, aside from the eviction stuff that we're going to go through here, what I'd like you to take away is feel comfortable practicing in a JP court. It is the people's court, and we should be doing our best to make it as pleasant as an experience for you, even if the outcome isn't the way that you wanted it. So here I put on the board, on the teleprompter, is the map for JP3. I put this up because this information is relatively new. I think in January of 2022 is when the JPs started using a new precinct map. So in my area, it's long, yeah. So here you see, if you can see me, I'm pointing right up here. This used to be the 5 Points area. I love JP3 because I think that this is the heartland of El Paso. this whole area right here. This is the old Central, and now we're in the new Central right now. But we lost this area, okay? Now, we're extending the final boundary that you see right there is George Dieter, okay? We used to end right here, which is Bacchus or Catnip, which is in the Viscount area. This big one right here is going to be Lee Trevino, okay? So just to show everybody, the last line that we have right over there is going to be George Dieter. Where am I? That's George Dieter, Lee Trevino. The purpose of the expansion, the JPs hadn't undergone an expansion in approximately 30 years because the JPs had always opted out of it. The county commissioners are always part of the expansion. The city reps are always part of the expansion. It's always based on the census. The census ended in 2020, or that's when we turned in our information. And the purpose of remapping the JPs or redistricting us was to equate all the JPs with a similar amount of constituents. Every JP has about anywhere between 106 to 110,000 constituents in there. Previously, I was the second least with 78,000. I want to say there was JP1 who was 61,000. So my area grew approximately 35%. His area grew about 42%. And then some areas like JP4, if everybody's practicing Judge Bustamante, has reduced dramatically, and rightfully so, because it was just about time. So a lot of that area that if you're having to file your cases in JP3, I'm sorry that you're having to go down there, but I'm not sorry because I get to see you, okay? Because there's some people that are right there by Lee Trevino that are coming all the way downtown, okay? So now, what we came here for, evictions. And as I start with evictions, I do love coming out here and talking about evictions, and I am going to do my best to answer any questions. I know everybody may have some questions, but we cannot give advice, we can give information, okay? So if for some reason I'm kind of straying away from your question, it's for that purpose, and I'll let you know, if it's too fact specific, too scenario specific, if you just had a case in the court, something along those lines, I may not be able to answer the question, but this is geared to provide information. And maybe if you ask a question, I can think of an instance that happened in my court that happened a while back, and I said, this is the way I saw it in my court, okay? So we're gonna break it down into three parts. The first part is going to be the pre-trial. This is anything having to do from you decide that you would, for the property owner is gonna evict a tenant, the steps that you're gonna take. Oh, that should say trial, I apologize, and the appeal process. I gotta stay closer. Okay, so the landlord, the way you start the eviction process is by giving a notice to vacate, okay? Notice, yes. Yes, I can share this with you. The landlord must give notice to vacate. Texas law says 3 days notice to vacate before a petition is filed. Something that's happened in my court before, somebody gave a notice to vacate, let's say on a Monday, then they come in on a Thursday and they file the eviction. We get to the hearing and they said, well, I didn't get 72 hours notice. The eviction was filed too soon. I asked the landlord, when did you give the notice to vacate? Well, it was hand delivered. I don't know when I gave it. It was sometime during the day. Okay, well, you filed the eviction here on on Thursday morning. It could be 72 hours if you went that time in the morning, but they went first thing in the morning. The notice to vacate was given later on in the day. So I was like, based on your information, I cannot rely that you gave the 72 hours. Case dismissed, has to get refiled. Okay? So take that as you may. Just make sure that you give the 72 hours before you do the notice to vacate, before you file the petition. If the lease, and sometimes you guys have wonderful leases, these leases will provide for a different amount of time. Sometimes it says 1 day, 24 hours. That will govern, okay? Just make sure that you point it out to the court. Filing your lease with your petition is very helpful. It's always helpful, okay? Let's see. The petition, and this goes along with, anybody can practice in the JP court. We will provide the petitions to you, okay, if you don't have your own petition. The petition will ask how notice was provided for the notice to vacate. Did you give written? Was it mail? Was it in person? Okay. So, it's helpful to provide proof of notice to vacate. If you do a picture if you sign it, or you get a signature from the tenant. Yes. Yes. So I'm not saying that I want proof. So, testimony is proof. Okay. So if that's a type of evidence. So if you were to say, I gave it on this day, if you've had a bad instance, you felt like you got burned, that you weren't able, that you can't document your conversation with them, then there's other ways to do so. Okay. I mean, your picture on the door, the signature. I mean, I understand if they're not going to want to give a signature. Include a military affidavit if the defendant is not active military. If the tenant is military, the eviction proceeding will be stayed, meaning it will be stopped, just like a bankruptcy. Yes, sir. No, that it should be. I think that's fine. Let me see, because I get that's going to be fine. Notice if that's your method of communicating with them. Okay. To the military, that if a tenant is in the military, then the eviction is stayed. If they're, I'm sorry, it should say if the tenant is in the military and they're out, they're overseas, it will be stayed. I apologize. If they're in the military, they're living in there, they're working at Bliss, you're able to go ahead. I'll make that amendment in there. Let's see. I'm getting too far away. Thank you. Well, let's see. The notice to vacate. This may answer your question about email. May be given in person. Personally given to a tenant, another resident who is 16 years of age or older. Okay. Pardon? No, does not need to be on the lease. Does not need to. Being on the lease, I'll get to that. It's going to be, you're going to have issues with it more upon appeal than anything else. Okay. Personally delivered to the premises by attaching notice to the inside of the entry door. And I think this, and I'm going to retract what I said about email. May be given by mail, regular mail, registered mail, or certified mail. It does not have to be certified mail. It does not have to be certified mail. Calculate the date from the notice was received, and usually we presume that it's within 3 days in Texas. And I take that back. Text or email is not sufficient unless it's stated in the lease. Okay? So even though you've been communicating with them, by Texas law, it is not sufficient notice. For the most part, the lease is going to govern. Yes, that's not unconscionable. That's perfectly fine. The question was if, because Texas law does not provide, I'll get back to that. Texas law does not provide that text or email is sufficient notice for notice to vacate. For example, you text me, get off my property, right? That's not going to be good. However, in a lease, if you stipulated in the lease that we can give you notice, I mean, you're going to give notice for various types of things, I'd imagine by text or by email, and you include that you can do that in there, that is okay. That you can give them notice to vacate by text or by email, that would be sufficient. Sure. That would be okay if in the lease. If in the lease. If in the lease. There's more often than not, the case that I hear do not have a lease. Yeah. Sure. If by the lease, if it's in the lease, that is okay. But if you start off, I mean, if you rent to your brother and you don't establish any type of lease other than pay me $600 a month, then we don't have a lease. Okay. Or we're not going to at least have those things documented like we'd like to have. Right here, this is a notice to vacate chart. Yes. Like yes, on the, like kind of the hurricane door, I think is what it means.
Everybody that is attending will receive the PowerPoint, and you can just wait, write down your question, and if it's time for meeting, we'll go ahead and answer those. If not, you'll get we can send an email and we'll answer more. You guys have a lot to talk about, and I know people are gonna start going back to work, and we just wanna make sure everybody gets a chance to hear your questions.
Thank you. I'm as chatty as my mom, so I apologize, but I'll still answer questions. It's okay. Pre-trial, the petition must be filed in the correct precinct. This goes back to why I was showing that map from the very beginning. If you file in the wrong precinct, then the case will get dismissed. You'll get all the way to trial and the case will get dismissed. We do our best. We are told from the Texas Justice Court Training Committee that we cannot reject any filing. Okay. So if some of you are used to e-filing, you file the case in the wrong precinct and you're like, why didn't you tell me that it was in the wrong precinct? We have to accept those filings. We must accept those filings. Okay. It's a loss. I understand that it's a loss on your behalf because you paid the filing fee for it, but we're going to accept it. Versus sometimes if you come in person and then you say, is this in your precinct? My staff is told, because we don't want to make the mistake, we just give a binder with all the streets, and all the JPs have a binder for any streets that are germane in their district, and it's going to tell you that you can file in that district or not. Okay. If you're in JP 6.1 or 6.2, that's going to be out in Clint, Socorro, Montana Vista. I'm not sure that there's a line. I think there's an imaginary line that divides the two, but I think that you can. That's what I was told. But I think you can still file anywhere in the precinct. Like if you want to evict somebody from Montana Vista and you file over in Clint, you can do so. Look to the lease for specified terms, amount of rent, terms of lease, notice to vacate. Leases, I mean, I think I'm speaking to the choir here. Leases are so valuable. They're very, very valuable. Oftentimes in our court, like I said, 50% of the time or more, there's not going to be a written lease. It's going to be a verbal lease. Probate. If the property is in probate, then the case is going to be stayed. The JPs cannot hear that case. Okay. If it is in probate, we will stop everything. If it's pending, and this is just more off the top of my head. If the property is like, you'll have sometimes where people are renting to own. Okay. The eviction court, the JP court, we're not there to establish title. Title exists. We just follow the title. Okay. So if it's a rent to own issue and somebody says, I've been making the mortgage payments, and they can show that it was a mortgage payments, it doesn't matter. We're not there to decide who has the title. The title is already where it is. Okay. Tenant at will, typically month-to-month lease. So this is just like as far as the lease terms are concerned, month-to-month lease. If it's not specified because you don't have a written lease, it's going to be month-to-month. Contents of petition, a description including address of the property sought, a description of the facts and grounds for eviction. There is 2 slots in there. One is going to be for back rent, and then there's another slot that may say other lease violations. And if you can specify in there, that's perfectly fine. In other courts, if you don't plead for it, like in higher courts, if you don't plead for exactly what you're asking for, you may not get it. Okay. In JP courts, we do allow people to amend their pleadings in person orally. Okay. Case in point, you file your case in February, but your case isn't heard until, let's say, late March. And the amounts that you have in there are only going to go up till February. We'll still allow for the March amounts. Okay. The March back rent. A description of when and how the notice to vacate was delivered, the total amount of rent due and unpaid at the time of the filing. If there's attorney's fees to be sought, typically now we're talking about documents that an attorney would file, and they would always ask for their own fees. Name of the person that petitioner is seeking to evict. Okay. Now going to the question as to any other occupants that may be in the home, that this is relevant because it's it's going to have an issue under appeal. If you file a case and you say John Doe and all other occupants, you didn't know that, but you knew there were other folks in there, you didn't know who was living in there. Jane Doe files an appeal, she cannot appeal the case because she's not on the lease. Okay. If the person is named as a named party on the lease and the landlord wishes to evict them, they must be named on the petition. All other occupants will be, I've never had an issue with it just being all other occupants. Trial in JP courts. The trial date must be set not less than 10 days, not more than 21 days after the petition is filed. Okay, so just, I don't think we've ever had an issue. Anybody come up with an issue? Most JP courts are kind of hearing these things like clockwork. We have a date. Every court has one at least once a week where we're hearing these cases. Before, during the pandemic, they would allow us to extend times. We're beyond that. I think they've shut down just about every Supreme Court order that we've had from the pandemic. The only one that still exists is relevant to JPs that says that we have to ask in a trial if there's any application for rental assistance currently pending. That does not stop the case from proceeding. We just have to ask that question, and we'll ask it to both parties. If we can stay a case, meaning we can abate or we can hold off on the case for 60 days under the agreement of both parties. Both parties have to agree. Typically, if I start the questioning and ask the landlord, do you want to hold off for 60 days? The answer, I've been like once or twice that the answer is no. Usually everybody wants to go forward. So I tell the tenant, I understand you would like to stay the case, but we are still going to go forward on the hearing today. Okay. And if you don't mind, I'm just going to stay over here because it's harder for me to click one the other way. Citation must be served at least 6 days prior to a trial. That's when the landlord will, that's when the constable will go out and serve. Repair and remedy issues are not relevant in an eviction case. Those claims are only valid if rent is current. Repair and remedy, is anybody here familiar with the repair and remedy? Okay, oftentimes we'll have like the tenant, they'll create defenses there on the spot. And they're going to say, well, my sink wasn't working, or the door, this was wrong with the door. I told them to fix the door. Those are more repair and remedy issues. That is a separate cause of action, okay? And the only way that they can file that is if rent is current, okay? However, I'll say this, if I've had issues with, let's say heat, something that's made the dwelling, almost inhabitable. Doesn't have water, doesn't have running water, doesn't have heat, does not have air conditioner, then sometimes I will come off on rent as a result of that, okay? And then you may request immediate possession. I'll go into the immediate possession. You can request immediate possession of the property once you file for the eviction. Okay, it's very rare. I think I've done one once in the 4 years that I've been there. The judge will set a bond amount that you would have to pay, which is typically about 1 month's rent or so, and the cost of the suit and any damages that may result if the tenant were to actually win the case. Okay, so you can seek immediate possession. Like I said, it's very, very rare. Then ultimately the judgment for eviction is granted or denied. Back rent is allowed to include prorated amount for current month up to $20,000. So, and I put the $20,000, it's been the JP limit since about 2019, I think September 1st of 2019. Prior to that, it was $10,000. And we don't usually get those amounts in residential evictions, but on commercial evictions, we will. Very easily. Court cannot award late fees, utility costs, collect on a security deposit, or set other penalties in an eviction suit. So oftentimes, one thing that's going to clue me to something like that, if I see that the amount of rent each month is $925, the amount being sought is $1,192.15. That automatically tells me that there's probably utilities built in here somewhere, okay? And you cannot collect for utilities on an eviction case. I have seen language in a lease that says any amounts paid for rent will go to any arrearages for utilities or late fees first before they're applied to rent, okay? So that's how sometimes I'll see those funny amounts. The appeal must be filed within 5 days. And usually the judge will tell you when the appeal should be filed by. Possession is granted, tenant must be out by the 5th day after the order is signed, and the landlord may request a writ of possession on the 6th day. The writ of possession is when you go to the JP court, you would pay $225. Then you would go to the constable of that JP, and then you set up an appointment with them where they can they'll keep the piece of the person is removed from the property. They won't do any heavy lifting. I've asked. Okay. But, and I think they charge, I want to say $100 or $225 for going out there. And if it seems to take a long time, they may have an additional fee of $25. If an appeal is requested, tenant must pay within 5 days of filing the appeal. This should say of appeal is, or if this is a case for non-payment of rent, then the tenant must first appeal the case, okay? And then they would need to pay rent during the pendency of the appeal, and that rent would be paid within 5 days of filing that appeal, and it goes to the registry of the court. The landlord, property owner would not be receiving any money at this point, okay? Typically, I'd say that cases on appeal, they were heard about within 1 month's time, okay? The JP court has to send it up to a county court. At one point, there was 7 to 8 county courts who were hearing these types of cases. Now it's more to like 3 judges who I think are hearing the cases. I think you know. And I'll just a little bit of back way of how that could have happened. There's 3 courts. Actually, there's maybe 3 courts. The ones that come to my head are CC3, CC6, a County Court of Law 3, County Court of Law 6, Judge Baeza, Judge Gurita. Those are the ones who are civil courts in the county courthouse for county courts, okay? The other courts that are county courts they typically hear criminal cases, okay? County Court 1, County Court 2, County Court 4, and then you have CCR 3, CCR 4, CCR 1, CCR 2. During the pandemic, because there wasn't a lot of criminal cases getting filed, they wanted to help out as much as they possibly can, so they were helping out with the evictions. The criminal cases are starting to increase in the filings. They're getting out of of the eviction cases. So I want to say it's 3 to 4. So if there is a delay in the eviction appeal, it's as a result of that, likely. It's always fine to reach out to the county court to ask them when your case is going to be heard. A writ of possession is good for 60 days. What I have seen happen in the court is the writ of possession is obtained and kind of held over the tenant's head, okay? For example, you have a tenant and it just happened within the past couple of weeks, you have a tenant who owes $1,200 and the landlord says, I want to go ahead and get the writ. And the tenant says, well, I'm going to get my income tax return, and it's going to be $2,000. I'm going to be able to pay the back two months rent, and I'm going to pay 1 month rent in advance. And the landlord says, or the property owner says, I'm still going to get the writ. And that just because I'm going to make sure that you do. Okay. And then they kind of squash it later on, however you want to do it. It's not for our courts, and I don't even allow that type of conversation to go on in the court. I ask somebody to go outside because we cannot get involved in any negotiations. And that's where I go with judgment versus agreement of the parties. If the parties do not have agreed, the judgment is going to stand in place. Okay, if you do have an agreement, it's always good to get stuff in writing. The appeal process. The bond is set trial by the judge. It's usually 1 to 2 months of rent that the appealing party would have to pay. Okay. They do so by filing filing the actual bonds. Let's say the rent is $600 and I set a bond at $600. They could come in, the tenant would come in, pay the $600, or they could file an affidavit of inability to afford costs, meaning they don't have any money to do so. Okay. Those inability of affidavit to afford costs can be appealed. Let's say, no, I saw them with an Escalade outside their front, their house. I had that a Corvette. I think they have more money to them. You know, they're coming in and out with bags of clothes. Then those have come back to the court and we have a hearing on the inability to afford costs. Only a named party on the petition can appeal. So you have, because I mean, that's a very common reason to evict somebody. More people in the property than who the property was leased out to. Only the person on the petition can appeal. Okay, so if people's siblings start staying in the house, they cannot appeal the case. Only the named party. Rent is paid to the court pending an appeal. It goes directly to the court. Now this needs to be commented upon, but I can't really get into the weeds about it because it's a very, very long statute. If a tenant fails to pay rent during the appeal, a writ of let's say I grant possession to the landlord, then the tenant wants to appeal the case, they appeal it timely. Okay. Now, part of that appeal, if it's for non-payment of rent, they're going to have to pay the first month's rent to the court registry. If they do not pay within a certain amount of time, you can get a writ of possession. Okay. The case now it depends on where the case is, and that's why it's kind of getting into the weeds, and it's a very, very long statute. We just had this issue come up. But if the case is with the county court, has the case already gone up to the county court? Has a JP sent up to the county court? Is that where I'm going to ask my writ from? Or did it stay in the JP court? They haven't submitted it yet. They haven't paid the first month's rent. Check out the property code, okay? Or seek legal, if you don't like reading legalese, understandable, that's the section right there, protects property code, section 24.0054. And it does need a look, a second look, a third look. We just had an issue not long ago where the JP and the county court were at odds. And the JP court was right, actually. Well, it's because the county courts don't really deal with they don't like the evictions because they don't usually deal with them. And it was a criminal county court. So, okay, lockouts. When to lock the door. A landlord may not exclude a tenant from, this is for residential. A landlord may not exclude a tenant from entering leased premises unless exclusion results from bona fide repairs, construction, or emergency. Removing contents of an abandoned tenant. May not change the locks or intentionally prevent a tenant from entering the leased premises based on delinquent rent unless stated in the lease or the tenant is delinquent in paying all or some of the month's rent and the landlord has mailed at least 5 days prior or hand delivered or posted on the inside of the main entry door stating the requirements of the property code. Look to section 98.0081. These aren't stuff that comes to the court, so I can't comment a whole lot on this stuff. This is stuff that most of you guys would do on your own. Commercial. There, yes. I think it's the inside. That's the way it's written in the law. I want to say it's like a hurricane door, that wind door. No. Don't go inside the premises. Don't. Thank you. Yes. Oh, is it a wind? Yeah, that wind door. What is it? What do we call it here? Storm door. There you go. Okay. Sorry. Thank you. Okay, commercial. A landlord may not intentionally prevent a commercial tenant from entering the leased premises unless exclusion results from, you guessed it, bona fide repairs, construction, emergency, removing contents of an abandoned tenant, and changing the door locks of a tenant who is delinquent in paying at least part of the rent. So that's kind of the big thing between commercial and residential. In commercial, you can lock somebody out for non-payment of rent. Okay, there are requirements to it. Locks are changed. The landlord must place a written notice on the tenant's front door stating the name and address or phone number of a person, company where a new key may be obtained. Tenant must pay delinquent rent and key only be obtained during tenant's regular business hours. Okay, so that's a big thing for non-payment of rent. You can lock out on commercial. Other issues, may not turn off utilities before you have a judgment. That will result in a writ of restoration of utilities. They'll come back into our court. May not turn off utilities unless tenant has notice for bona fide repairs, all that good stuff, construction. May not lock tenants without proper notice, residential or commercial. May not enter a property without permission for want of getting bid or shot. Writ of possession is valid for 60 days. I always highlight that because it seems to be a valuable tool. If somebody, if they're, you think somebody's going to pay rent. Okay. Emotional support animals and service animals. I had this come up one time in the court. And I'll tell you, if you ever see legal aid on the other side, there's an issue with the case. Okay, I'm not saying that legal aid is right or that they're not right. I just know that it's a red flag to me that there's something about this case that is unique. I had a case in the court where it was an apartment complex, and one of the individuals in there, the tenant, got a dog. Guess what type of dog they got? Pit bull. There you go. All right. So, and I say just because I know they get a stigma. I don't advocate for or against pit bulls. I don't know them. But got a pit bull, and the dog would bark a lot when the tenant wasn't there. Okay. Everybody else had a problem with the pit bull. Obviously, there had been a lady that was renting there for 20 years, and the landlord files an eviction notice because there is a no pets policy on the lease. There is a case from federal court here in El Paso that says the law does state service animals. There's a clause in the law for federal law for service animals. Okay, we see them in the airport and so forth, right? And as if you've been to the airport, now you see a whole lot more dogs and cats that are flying. Okay, it does not distinguish between service animal and emotional support animal. Okay, so that, and then it was a balancing test for the court for us to decide, you know, is this emotional support animal? What qualifies that as an emotional support animal? Then we kind of get into an issue of health and safety as well. Okay. In this instance, this tenant had legal aid representing them, had a meeting with a psychologist or a psychiatrist from California on Zoom, and then received a prescription for an emotional support animal. Okay. And we got into the weeds. So just know that does exist. Okay, that does exist. On whichever side you're on that argument, but it does exist. Okay, yes. Well, I'm telling you, there's no distinguishing factor in the federal law. Okay, it came from one of the federal judges here in El Paso. Yes.
Some people like dangerous animals. There is a case.
Sure.
Another case that we heard that talks about if the type of animal there affects the landlord's ability to insure the property,
Okay.
then the emotional support thing sort of goes away. So, I mean, there is a precedent that just because they get this emotional support animal there, doesn't necessarily mean that the deal is done. Check with your insurance company. Some insurance companies have a stipulation where certain types of animals are not insured.
Okay.
And that might be something that the landlord would want to take a
Okay. That wasn't in this case, but that's a good point. It was state. There you go.
One of their advanced real estate.
There you go. Thank you. Yes. Yes. So the issue with the insurance, I won't be able to answer that right now. There could, like you said, the gentleman says, there could be another case out there that says otherwise. I don't know. Okay. The case that was presented to me and the case law that they presented to me on that day did not refer to anything regarding insurance. Okay. But a pit bull can be an emotional support animal. Anything can be an emotional support animal. Cannot withhold security deposit for rent. Security deposit is a completely different issue. And let me see, do I say it here? Oh, okay. In regards to the security deposit, there are stipulations that you must follow in returning the security deposit or not returning the security deposit. Okay. One big thing I've seen or defenses that I've had come up is the landlord will say, well, they didn't come in and give me a forwarding address. That doesn't mean that they don't get the security deposit. Okay. But just know there are rules. And if anybody, I always tell everybody, if you're going to play the game, know the rules. And I mean, for landlords, that's a big one in regards to security deposits. Bankruptcy is filed by the tenant before judgment for possession is entered. The case is stayed. Luckily, I've never had that happen. Okay. And I mean, so most of the time, I mean, in Texas, I would say Texas is pretty straightforward. You know, I know I've heard of other states that where tenants can stay for longer periods of time. Texas is kind of straightforward. You know, there was a loophole in during the pandemic, which thank God for us that nobody realized too much. But if you asked for a jury trial, had a tenant asked for a jury trial, they would have stayed in there for 1.5 years. Because there was nothing we could do to congregate folks like the way we're in this room right now. And I just say thank for us because that would have created such a big backlog for us. Okay. One other thing that you will see in our courts is we do get, we are required by the Supreme Court, this is recent, that we have to give legal aid an avenue in our courts. We have to tell them when we're having our hearings. So I have this one gentleman from legal aid that always comes to the hearings. If they're not there, we let them know and we set up a Zoom or we set up a screen outside from a tablet so that if anybody wants to talk to them, they're there for the benefit of tenants. If you're a landlord, you ask them questions, they may not, I wouldn't know because I never asked them a question as a landlord, but I would imagine they're not going to answer your questions. It's only for tenants. Okay. Maybe that's why there was an increase of appeal cases. I don't know. If there's any questions, I'd be more than happy to answer them.
If you have a tenant that the eviction was granted and you have the 5 days, do you still have to pay for that writ of possession to get your property back if they did not appeal?
Yes. Or you can wait till they leave. Yes, sir.
Just a quick question. It seems like qualifications to run as JP, there are none.
I'm not sure that it requires, I don't know what educational background it requires.
Yes, and so isn't there something that we can do to say at least they need to watch people's score or something on a regular basis? Because I've seen some horrible ones. They just go there to marry people and get them.
Sure. So I know that, I mean, having education, even in your business, education anywhere is going to be great. You can have, good realtors, bad realtors, good JPs, bad JPs. There's always a push on the legislative side, at least that I've heard of. I've never been there for the arguments, to have it be a requirement that JPs be an attorney in populations in counties over 500,000, but it gets a lot of pushback. I think when you try to do it, have them have a educational requirement at any point, there's a lot of pushback because there's so many counties in Texas and every county must have 4 JPs. And yes, and there's, I've heard, when I went out to the trainings out there, I meet some of these folks from the rural counties and it's very difficult to fill those spots. So I don't know. I appreciate the question. Yes.
You can go ahead.
Can you have communication with the tenant once you file the eviction?
Sure.
I can still make phone calls.
Yes, absolutely.
If you can't slide it in the door or in the hurricane door or anything, can you leave it in the mailbox?
I wouldn't leave it in the mailbox just to fix it you can tape it on the door.
Tape it on the door?
Tape it on the door.
Okay. Yeah, if it's in
and
what if
take a
it's-
picture.
I have an envelope. I left the envelope on the mailbox that they do check because it was empty. They just don't want to answer the door, the phone calls, or anything like that.
So,
do
I
have a
mean, that's why
picture.
sometimes I've had that happen, you know, where they say, I posted it, and then I have the tenant say, no, it was never posted. And then there was a picture that was taken. It's like, here's a picture of something that I posted.
Okay,
then-
so with the picture, it's fine.
That, I mean, to me, it convinced me.
Okay, sorry, quick question. I know you not keep. Does it,
If you stipulate it on the lease, I'd say still look at the security deposit law, just in
Okay.
case. Yeah, it's, I have it right.
Anyone else have questions?
I'm sorry, I was looking for the, just look, I would still look to the law just in case. If you can, if in the lease stipulates that you can deduct from the security deposit to pay rental amounts. So I would look, I mean, they're very distinct and separate. So I would just direct you to the Texas property code under that part for security deposits.
I got a question, Judge. And this doesn't necessarily pertain to say that you would say this or do this in your court, but does a justice of the peace have the authority, the power to overrule what a contract says and take it upon themselves to make a better, happier decision for someone, or to say this would be the more fair decision rather you dropping the hammer on somebody?
I think that the courts should look to the law and if the contract, because the contract is basically a law, you know, you're having a meeting of the minds and you're agreeing to something. I would hope that the courts would look to that. Sometimes if there's on the lease, I'm sorry, on the petition that you see, you know, it's going to say back rent is owed. Right? And let's say it's $2,400 and then it says other lease violations. Okay. In a scenario like that, I can go through every single thing. Or if I see that and I say, all I need is just one to break this lease or to see that there's grounds for an eviction. And then in Texas, kind of the easiest thing to look after that is to say, okay, well, there's back rent owed. That's, you know, that's going to be inarguable. That's going to be arguable or not arguable for the most part. Okay. So in that case, I mean, like I would say, do I need to go through all of it? Maybe not, but I should pay attention to everything that's all the moving parts on there. And like, this is a discussion that Rogan and I had right before. Like I've had, it's nobody from this room. It was one of the housing authorities where there was rent that was owed in the amount like $8,000 to $10,000. It was a great deal of rent. And there was a switch over of the property. And in that, and then, so whatever ledger they had was, it was dated, there were holes in it, there were problems with it. And the tenant said, I said, well, I don't agree with everything they're showing here, but there's at least 2 months that I didn't pay rent. So I told them, I said, well, what we can do is we'll come back on a separate date and it's going to be about 3 to 4 weeks out, the next availability that I have. And then this is going to be my only case in the docket. We're going to just go through this with a fine tooth comb. And the landlord was like, I just want the property. I was like, well, you stipulate that, you know, only 2 months of rent are owed. And I said, yeah, that's fine. So in that case, you know, like to the detriment of the landlord, but they kind of acquiesced and were okay with that deal. Then I went ahead and did that. So you should always, I think that the court should always, we are courts of law. And I understand that sometimes some folks, and it doesn't, irrespective of whether you're a JP or whether you're in a higher court, courts like to operate in equitable terms a lot of the time. I still think that they should look to the law. Yeah, can a judge do it? Yeah, a judge can do it. Sure. They can also be wrong. I would hope they wouldn't ignore it. That's just my hope. That's a great resource of the dispute resolution committee. Yeah, I'm the chair of that board. There you. Well, thank you. But we have that. I've only referred a case out there once, and they were during the pandemic, we were doing it a little bit more, but I feel that the JP, at least in my experience, is more of a mediation than anything else, because we're talking to both parties in the same room as opposed to separate rooms. So, are there any other questions? Yes, ma'am.
How is the landlord notified if the tenant appealed within those 5 days?
Good question. You contact the court. That would be the best thing to do, is to contact the court. And another thing that you could do is you would contact the court to see whether or not the first month's rent has been paid. Because if you want to get, under that issue that I was talking about, if you want to get a writ, even though the case is under appeal, you're still allowed to do so. But if they haven't paid the rent, that's one way you can get that writ. Haven't paid it timely. Yes.
I'm on the district map. Are the property owners notified by the county?
The county was supposed to send out a postcard. I know that they did for the commissioners, and I kind of had to kick a little bit to say, why don't you do the same for the JPs? And I don't know. I think a couple of folks I know in the area got one, but
Is that property notification for the postcard? Because I remember when we did the flood maps, the owners were given a letter.
sure.
Mailed a letter.
Unfortunately, I don't know. That's your commissioners would be the ones to tell you.
Last question.
Building is owned or rented. We don't
No.
register rent.
Yeah.
We're not gonna go there. It's like I'm sure.
On the paperwork we file in addition, there's a box for bulldozer, and in our leases, or some of our leases, we have bulldozer, but I have yet to see bulldozer actually have it considered.
I know I've seen you once.
Yes.
And I know, but it was, I mean, if I have multiple reasons for an eviction, and one, like I said, one is enough, and usually non-payment of rent is going to be the easiest one, I won't necessarily go to the other ones. I mean, just like if the courts, like the JPs, this is what we're used to. For example, I have not long ago, a couple that was estranged, that was recently estranged or months ago, okay? And they wanted to get into all that other stuff that was not relevant to the courts. I said, let's just focus on this. Let me just bring you back because I need to get you out of the door. I need to give you justice. All that other stuff, that's not for at least my court, so.
I don't know, because I checked all three for my case.
Well,
Mine wasn't completely. Just it.
You, or not, but yes, thank you. Yeah. Yes.
How many appeals can tenants?
One?
Just one?
Yes.
So they can only appeal once?
Oh, well, I mean, if at the county court, it should end at the county court, unless it's an issue that needs to go up to a federal court. Like, for example, the one I was talking about, the dog, that one started out at JP court, went to a county court, then went up to the Court of Appeals, and then went up to the federal court. It was 4 different appeals. I think it moved to the federal court right then, because they were arguing a federal law. Yes, sir.
Question regards to the holdover tenants. Is it just a case, I don't know their name, I don't have their number, I don't have their email. I guess I would just take a notice on the front door and take a photo of that.
A notice to vacate.
Because it says landlord will provide holdover tenants a 3-day notice to vacate. How do I prove that to you if I don't have any of their, because I don't know who's in there?
You don't know the name of the person in there?
No, I know the person, there's extra people there.
So then the named person in there, and then there's an option for all other occupants. That's, yes. Yes.
Scenario. Owner decides he's gonna sell the property to a friend. They don't have anything written other than, I'm gonna give you a down payment of a certain amount of money because I'm going to qualify for a loan to purchase the home within, they don't even have a designated amount of time. So fast forward 12 years later, and now I get a phone call And so this person is now $4,084.37 behind. So the owners have moved to California. The people won't answer the phone, won't accept anything from the owners, and will not leave the property. So is the best course of action, based on where we are currently, the notice to vacate, or should this be something completely different?
So you're asking for advice. I can't give advice.
Oh, that was just a scenario.
I know,
Scenario.
but it was a very specific scenario. And situations like that, I've seen people just go forward with the eviction process. If somebody's not moving from the property that they don't own, it's been the course, at least that I've seen, that the owner is going to evict them from the property, or an agent of the owner.
Okay.
Or an agent of the owner.
Thank you.
Sure. There you go.
Okay, well, that was our presentation. Ms. Angela?
So if you send something certified mail and they don't sign for it the first time, but you get, like, is the first attempted delivery considered the date of notice? Like, because the post office.
There's a presumption that 3 days is, and you don't have to give the certified mail. I know sometimes you like to, but okay, you don't have to. I mean, because I had the issue come up, and it's 3 days from the date that you mail out a regular letter. It's presumed that it was received.
Okay, so a lot of information that Mr. Josh Herrera has talked about, you can find it in the Property Code 92, Texas Property Code 92. Also, Texas Realtors has a book regarding property management information, and it's very, very detailed. It says regarding posting notices inside or outside, 3 days, mail certified. I mean, it's very, very informative regarding evictions and security deposits. So I would recommend getting that. It's like $150, $190, but it's basically what is allowed, or what Texas Realtors is, I guess, backing on things like that. But I want to say once again, thank you to everybody. If everybody can please make sure you sign in, that's the way that you'll receive Mr. Herrera's presentation. And Mr. Herrera, thank you. Thank you very much.
There's one other thing I just wanted to say. I want to toot my staff's horn. When I got into office, for whatever reason, we had a backlog of cases. Our civil cases were in the area of 11,000 and change. Our criminal cases were approximately 48,000. Okay. When I got into office, we started a cleanup process during the pandemic. It didn't slow us down, kind of got a little bit better. So now our criminal cases, our civil cases went from 10,500, 11,000 to right now we have about 400 cases. And then our criminal cases went from 48,000 to about 2,500. So what that means is when you file a case, at least in my court, you'll get a quick turnaround. People always talk about courts, now they take so long. I think the JP court is the people's court. It should be heard as quickly as possible. There are some legal timelines that we have to deal with, but every case in my court lasts no longer than 4 to 6 months. So that's for my staff. But anyway, thank you for the opportunity. Thank you for having me. Appreciate you all.
On behalf of the committee, here's a little something. Thank you. Thank you.